What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. We are in Judge Holmes' court out of Texas. And this is a little landlord tenant matter where the tenant is jumping up and down screaming perjury, that her landlord is committing perjury. The story's kind of funny. I'm not going to spoil it in the intro. You're going to have to watch it. But yeah, there is a twist in it. But before I hit that play button, you know what to do. Hit the like and subscribe to your jump kick backflips. Let's go.
Harnage?
Yes, I'm Patsy Harnage.
Good morning. Thank you for
Good
being with us.
morning.
And do I have someone here for Mary Crosby?
Yes, the defendant is present.
Good morning, Ms. Crosby. Thank you.
Good morning, Your Honor.
All right, Ms. Harnage, why is this eviction being sought?
Non-payment of rent.
Non-payment. All right. And under the agreement, how much is there a monthly rent?
Yes, ma'am.
How much is that?
I'm so sorry. I have so many tenants. Make sure I get it right. $1,700 a month.
Is there any subsidy from the government?
No.
What months are paid or unpaid?
July and August.
Was this a CARES property?
I'm sorry?
Is
No.
this a CARES property?
No, Your Honor.
Okay. And what day and how did you provide the notice to vacate?
I provided the notice to vacate certified mail. And I also sent it to her. I also went over and I told her that I served the notice. She was in her car, and I told her that I served the notice to notice to vacate. And then she said, "Oh yeah, there's a notice in my mailbox, but I haven't went and retrieved it."
All right. What day did you mail it?
I believe it was the. Let me get it right. I'm so sorry.
Yeah, Judge is getting a little antsy. You see her kind of dancing in her chair. These are questions that are asked at the beginning of every landlord-tenant hearing, and she should have this. She should have this information, which kind of leads into the credibility of what the tenant is about to say. But we'll see.
July 15th.
All right. Good morning, Ms. Crosby.
Good morning, Your Honor.
Ms. Harnish is here. She says she's on behalf of the landlord and that this case is a financial situation. She said that under the lease, the monthly rent is $1,700. Is that correct?
Yes, Your Honor, that is correct.
Okay. And then she said rent has been unpaid for July and now August. Is that correct?
Your Honor, before we continue with the merits of this case, may I present to the court perjury by the plaintiff in this case? Your Honor, the plaintiff has committed perjury in this case. In her
What did
sworn,
she lie about?
I'm sorry?
What did she lie about when she just told me? What's
In
wrong?
her sworn petition, she claimed that she delivered a 3-day notice to vacate on July 15th by
That's
certified mail. Yes, ma'am. And I have the proof. If you would look at Exhibit A and Exhibit B as in boy. Exhibit A shows her petition where she wrote that she did deliver it by certified mail on July 15th, 2025. Exhibit B shows that there was an attempt made. So this is the slip from the USPS tracking. It shows that the attempt was made on July 17th of 2025. No delivery was successful. It marks here, no secure location available, no authorized recipient available, and signature was required in this case, Your Honor. Her verbally telling me she sent something does not count for an actual delivery.
So you got a notice that you had a certified mail and didn't go get it?
I didn't say certified mail. It said
you haven't. Told me that it said required a signature. So you had a notice that you had a letter that needed your signature and you didn't go get it?
Yes, ma'am.
That doesn't count as her not delivering it to you. That counts as you refusing to accept it.
Well, I did. The reason why, Your Honor, during that time I was ill
I understand why, but that
Okay.
doesn't change the fact that she did what she was supposed to. Your
Okay.
failure to pick it up doesn't mean she didn't reach it to you.
Yes, ma'am, Your Honor.
All right.
Under
What
property
other
code
things did you say she
24,
lied about?
I'm sorry. I'm sorry, ma'am, I can't hear you.
What other parts did you say she was perjuring?
Okay. Under property code 24.005, it states that the notice period begins the day the notice was delivered and not mailed, Your Honor. The plaintiff used certified mail only, which requires a signature. She does not have a receipt showing my signature or any delivery. In
That's
other
because
words,
you
from
admitted you didn't go get it. That's what you just told me.
yes,
That
it
you had
says,
the notice, but you were busy, you had other things, and as a result, you couldn't do it.
yes, ma'am. They sent a notice saying that they attempted to deliver, but no delivery was made. There was just an attempt.
I know. We all agree on that. You just
Yes,
told
ma'am.
yourself that that's what happened.
Yes, ma'am.
Okay. But you knew she was
Also,
mailing you the letter.
I'm
So she told
sorry.
you that.
Yes, it does say that if the attempt was made, but it was made on 7/17. She says that she sent it on 7/15, Your Honor,
That's
which is
reasonable. The mailbox rule under the law says 3 days is presumed before delivery occurs. It sounds like
okay.
you got there on day 2.
Okay.
If she mailed it on the 15th and they were trying to get it to you on the 17th, that's 1 day faster than the law assumes.
Okay. Well, I was looking at Texas Property Code 24.005, which states that the delivery begins the notice. I'm sorry, the notice period begins the day the delivery is made and not mailed.
That's correct. So, Miss Crosby, you're absolutely right. The rule, though, about when something has been mailed is delivered is 3 days. So if I mail it on the 1st, the law presumes that it's been delivered in 3 days. Here, you just acknowledged and testified that you got it on the 17th, the notice to you, you just didn't have a time. You had other things that you didn't go pick it up. But indeed, it got to you within 2 days of her mailing it.
Yeah, there does say a certified
All right.
mail slip, but it
Yeah.
doesn't tell me that it's hers. I didn't know what it was, Your Honor. Also here, I did cite 2 cases, Gore versus Homecomings Financial Network, and also Kennedy versus Andover Place Apartments, where the Texas courts, the appellate courts made a clear, strict compliance mandatory of the 3-day notice, and states that the 3-day notice is upon delivery and not mailing. The actual person has to receive it. Your Honor, she also did not, she could have also sent it, she could have sent it by mail, by regular mail as well as certified mail, which she did not, to make sure that it was delivered to me. Yes, ma'am. This possession for filing, Your Honor, I would like to bring to your attention that this case was brought to an eviction court purely for monetary gain. There was never an eviction in place, Your Honor, because I had already moved out by the time she
Ms. Crosby,
filed.
have you moved out of the unit?
I moved out August 4th.
Have you returned the keys?
On August 4th.
Ms. Harnish, is that correct?
She left the keys underneath the mat.
So she moved out and gave you the keys back?
She left the keys underneath the mat.
She moved out, you got possession. You can sue her for the money that she owes, but she moved out, she gave you the keys back, you got what you wanted back. Judgment for the defendant. You can appeal me, Ms. Harnish. I'll put it down at $500. Okay?
Your Honor, one more thing, please.
Ms. Crosby.
Ma'am, I know, yes, ma'am.
Okay.
But the plaintiff is also holding third-party property that belongs to Appliance Warehouse. Your Honor, I'm begging the court to please direct her to release that property.
I can't. That's called injunctive relief, and I don't have that authority as a justice of the peace.
Okay.
Please contact the law library for how you might pursue that. But for the eviction, which is something that is relevant to this court, you moved out and gave her the keys back. Ms. Harnish has the right for 4 years to pursue you for the money that hasn't been paid, if indeed that's true. But in terms of possession, she's received that back, and that's ultimately the goal of the eviction court. Okay?
Yes, ma'am.
All right, ladies, y'all have a good afternoon. All parties are excused.
See? Oh, the pettiness on both sides. I mean, the tenant's right. If she moved out, why is she in eviction court? She can sue for, the money owed, but that's in a different court. This landlord should know better. She said, I have a lot of tenants. Yeah, she should know how this works then. Anyways, I like the argument. I never got it. Yeah, but you got the slip. Could you imagine if tenants could just avoid evictions by just avoiding service? Oh, that would make it. Oh, that would be crazy. That'd be crazy. All right. that's it. There's still about a minute left of this video. I don't know what's left. I don't know what's going to happen. I don't remember after this part. But hopefully you guys enjoyed the video. Please hit that like button if you did. Yeah, that's it. That's all I got. Until next time, bye.
Thank
Either
you.
one can appeal me. It'll be $500.
Thank you.
What was the judgment for?
Judgment for the defendant. So there's a nothing for the plaintiff because she moved out. You got possession back.
Okay.
If you want to pursue her for the money she owes, you have 4 years under a breach of contract case for that.
Okay.
And Ms. Crosby, be aware, she can sue you again, or the landlord, it's not Ms. Harnish, whoever the landlord is, can try to pursue you for the money and any damages, security, any of those things that remained from it. An eviction is about getting possession back. If you moved out and gave her the keys, then she doesn't need an eviction. What she needs is monetary compensation, and that's something y'all can both pursue independently. All right?
Yes,
Do I
ma'am.
do it in your court?
If it is under $20,000, then yes, this would be an appropriate forum for it. If it arose out of our precinct and the lease, you could do it here. You also have a choice, Ms. Harnish. This is true for any lawsuit. You can either sue where the action accrued. So if it was a lease and it happened in this precinct, this would be appropriate. You can sue in the precinct where the defendant resides. So if Ms. Crosby's moved and she's someplace else, you can choose to sue her there. It is the plaintiff's choice about which of those two forums they want.
Well, I don't have an address for her. She told me good luck finding out where she is.
No, ma'am.
Ms.
You
Harnish,
have the address. The court has
Ms.
the
Crosby?
address. Yes, ma'am.
Ladies, or I'm not trying to have y'all dispute with each other here. I'm going to say that there is a way to sue someone even if you don't have their address. It's called alternative service. Look into that as well. Okay? Y'all have a good day. All parties are
Thank you.
excused. Thank you. All right, next is going to be 25-1105.